Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
How the New York Times actively vouched for the veracity of its false narrative.
We actually want all evidence to come out that's proper and appropriate evidence.
Blake Lively's attorney resigned, following Brian Friedman's massive update on their legal action, and truthfully, I don't find it unexpected Merle was obviously drowning from the first attempt to use just smoke to support a claim. And mirrors, and let's be honest, just a skilled magician may have performed that off.
So we kind of knew this was coming, didn't we? The collusion argument.
Probably the wisest course of action was to quit. Prevent her reputation from declining with that ship that is sinking.
I looked through every document, every email, every text message.
And following this information, Blake, officially, Lively's legal team is in pandemonium. And to be honest, time is of the essence. Nobody can even hold her accountable.
You guys were complicit here. You guys were involved in this every step of the way.
Defending a case that is gradually deteriorating, separated without any concrete proof to support. Blake's assertions resemble an attempt to release gasoline-fueled fire as soon as Brian Friedman made his shocking announcement. This case was obviously in free fall.
That's the whole point of a lawsuit, is you just start with allegations, and allegations are not evidence. They're just statements of fact that help establish this is the claim that I'm bringing.
Blake's case initially appeared to, such as the possibility of sexual harassment, allegations of body shaming during nursing, all the necessary components for a public play of sympathy, but the truth is that there's no evidence to support any of it.
Look, there's a lot of factual determinations that need to be made here, not legal determinations. And because there's factual determinations, you got to leave it to the jury. You got to give a jury the property.
Yeah, exactly. And so they're just saying, look, just let the facts decide. And the trier of fact in any case is going to be the jury. Unless it's a bench trial, then it's the judge. But this is not. This is a jury trial.
As Justin Baldwin's team dug deeper, the more Blake's charges began to appear as though the script was badly written. No mails, no papers, and nothing to display. She wasn't just making things up all the time. Blake's attorneys believed they had. It changed from a leg to stand on to quicksand.
There's some bad things that happen here.
The kicker is this. All of this was influenced by Blake's PR team. Additionally, even though it appeared that they were all focused on pursuing justice in actuality, it was about keeping an image that they continued to promote Conan and the team to battle despite the fact that there was none evidence to support Blake's assertions.
They hired, meaning the Wayfair parties, hired a crisis PR manager who orchestrated a smear campaign against Lively.
Perhaps they believed a simple PR twist might transform. The lawsuit was successful, but in practice, the court disregards the quantity of Instagram posts. You make the facts the main focus.
It wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
Conant was, as if that wasn't enough, under tremendous pressure from all directions. She is a high-profile representative of Blake, a customer who will stop at nothing to win, even when there is just no proof.
Reynolds and Lively wanted Wayfair to issue a statement taking the blame for Lively's bad press.
Then naturally came the 170-page official publication from Baldwin's group.
Baldoni's team drops a massive $400 million suit on Blake and a lawsuit against the New York Times. Then they publish 170 pages of perfectly documented texts and emails between all the parties that basically show Blake to be the aggressor. Here's the proof.
This document wasn't only difficult to. Blake's case was essentially destroyed. The allegations of sexual. There is no body shaming or harassment. Even close.
Yeah, and again, at the same time, Nathan assembled a team that could dominate social media through full social account takedowns by starting threads of theories and...
Hold that thought.
Here we go. Generally working to change the narrative. So it's impossible to know how much they planted and how much of it originated organically. Well, wait a minute.
Actually, everything. Blake's claim was methodically refuted. And more the case progressed, the more Blake appeared to be the one making the attempt to act like the victim with no proof, only a several assertions, and the more Conant. The more she resisted, the more she understood that nothing is being defended.
You're making a factual assertion that these people did something, seizing on it and amplifying it.
You may be wondering now, why didn't she, if this was the issue? I don't see it coming from day one. Don't recall, but there was a period when the massive media outlet The New York The Times gave their endorsement to Blake's case, and it seemed like a win-win situation.
This suit against the New York Times is hard.
Blake Lively's bad legal situation. Team most likely believed they hit the winnings when the New York Times released a video piece in December 2024, which makes her assertions appear almost impervious to bullets.
Here is the clip in question. Now, this video,
filed on Friday.
Thank you to
Private
Citizen
text
Journalist
messages.
for putting it on easily accessible. This was part of the article.
Oh, the
Mainstream media's pleasant flavor.
trustworthiness for a short while.
It appeared for a while that Blake had discovered the piece's most important source of support, titled "Anyone Can Be Buried Inside a." She was similar to the Hollywood slander machine. Golden Ticket is a last-ditch publicity stunt to accuse Justin of being the source of her. Wayfair Studios and Baldoni appear as valid as a judicial decision.
A campaign to tarnish Lively after she alleged that Justin Baldoni, her co-star and director, and Jamie Heath, the producer, had engaged in misconduct while shooting the film.
Considering the times, the same media behemoth that has been creating decades worth of history puts its approval stamp on something that has to be truthful, correct?
And that's what the New York Times is coming back and saying, look, we're not Blake Lively. We're not the ones making the allegation. We're just fairly reporting on what Blake is suing Justin and Wayfair for.
But as
with the majority of items that appear too wonderful to, the truth struck Blake's crew more difficult than they anticipated right when they believed that the periods in their corner the legal bulldog of Justin Baldwin. Brian Fredman took the initiative and offered a response. The wind would have been wiped out by that punch. Fredman wasted no time in identifying anyone, submitting a protest to have the new participation of the York Times in the case, and it was in fact a master lesson in legal altercations.
They decided not to run it for fear of defamation, I'm sure, for fear of you and defamation. So they didn't run it, but some of these TikTokers have done it.
Fredman of the New York Times claims wasn't merely covering Blake's accusations, they were essentially presenting them and confirming them as fact, so that it was difficult to tell whether they were penning a news story or a Fredman editorial made it apparent that didn't merely act as reporters, they acted as an advocate.
He mocked Baldoni in the process. He said, it's an effed up bad situation with what Baldoni, whatever his name is doing.
Fredman did not merely accuse the periods of bias. Oh no, he went further and accused of failing to follow the fair report, the privilege that safeguards media outlets. When covering legal issues, you are aware the type of defense that permits reporters to cover court proceedings without being embroiled in the controversy themselves.
If they would have said, Blake alleges that, or according to Blake, blah, 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 this happened, they'd be protected. But they said, and her title is investigative journalist. So she's an investigative journalist for the New York Times. So that is implying that she's done an investigation. She's actually looked in this. We can trust her.
However, the worst part is that, according to the Times, didn't only cover Fredman's. They presented Lively's assertions as truth that they didn't merely share with the public. Hey, according to Blake, this occurred, suggested that it had been looked into earlier, and verified it isn't reporting. That is forming a story.
The New York Times have looked into it, and this is what really happened. So now they're stating as a fact, not as an opinion, that this happened, and that's how they're going to get into trouble.
And by carrying out. Consequently, the shield was lost during that time. Includes the fair report privilege in other terms, they made themselves vulnerable to an genius move in a lawsuit, huh? Fredman's legal challenge was shocking enough on its own, said that the period wasn't only culpable for poor journalism, but of actively taking part in the Wayfair party's devastation, reputations.
Admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation.
They displayed Lively's version of what happened as if it were not just confirmed, but without a doubt accurate, and that poses a significant legal issue, speaking due to the fact that media outlets are not permitted to make unsubstantiated assertions as
facts.
If they're supposed to be the bastion of journalism, right? But, if they had just said it's the opinion, would this have mattered? Will this factor in the fact that they did seemingly have this for months due to the metadata and things that we're seeing?
Saying this is one thing. What someone says, however, it's another to state that this is what took place. Particularly if you haven't completed the leg endeavor to demonstrate the distinction between, additionally, advocacy and journalism. Fredman was prepared to label it hazy.
Out.
And so now they're saying like, hey, we tried to fact check. We gave you the opportunity. Oh, you didn't respond. Oh, if you would have responded, we would have maybe thought of things differently. But hey, we just went with what we had, so we can't be sued. So this is what they're doing.
Oh, but hold on. Things will get better. Release of the video and article wasn't only shady because to the manner in which the narrative was crafted and hurriedly concluded. With dubious timing, Fredman made discovered that the Times basically pushed. During the holidays, this composition was released. Little mentioning the Wayfair parties. Time to react.
Here's why he's suing them. It's super creative. They said, evening of December 20th, hey, Justin, here's all this horrible stuff we're going to print about you. You have until tomorrow at noon. We'd love to hear your response. He engages with them. He says, okay.
They seem to know precisely when to reveal the truth about maximum impact and the perfect timing. Coincidentally complemented Blake's PR plan.
And New York Times prints a story prior to noon with the partial information. And my guess is they were worried another outlet was going to hit this story.
As stated by Fredman, this wasn't simply subpar reporting, it was awful. It appeared that confidence had already devoted themselves to the narrative before they even offered the opposing viewpoint a fair chance to
protect themselves.
We're talking about the Wayfair parties over here, and it to me makes it sound like the Wayfair parties did that. And again, if that's the case, if you think that happened, investigate it. Do a series of articles. Let's see it.
The reality that
the story was completed days beforehand, prior to the Wayfair events even. Contacted and it didn't seem good. Gave the impression that the Times weren't curious about the reality. They were simply captivated by the narrative.
It's not unlikely. I think there's a high degree of likelihood that the court probably, on one of the arguments, and maybe it's the group pleadings, but will grant the 12b6 motion and ask Baldoni's side to amend the complaint.
Fredman's criticism was not limited to the timing. He disparaged the Times piece's ethical perspective. It wasn't only a case of unfortunate timing or the issue with the bad editing was that the media outlet had previously selected
seeds.
So you might as well just amend the complaint and clean it up now. So it wouldn't surprise me if that's what we see, but I do have to say that the arguments in this opposition were really good.
They had not only disclosed Blake's assertions that they had already chosen to support her up, leaving minimal space for everybody. Other person's account, it wasn't a balanced and impartial report, it was a biased support under the guise of his journalism for Fredman that went against the grain.
Line.
I mean, the arguments were really strong, so that wouldn't surprise me either.
All right. Whew, that was a marathon.
For Blake, what appeared to be a golden chance to strengthen her argument using the assistance at this moment felt more like a trap. What she and her group most likely did not expected was that the assistance from the media behemoth would turn into a two-sided
sword.
An intimacy coordinator, and Blake refused to meet with him or denied, said, I don't need to meet with the intimacy coordinator. I'll see you on set. I'm all good. So, then Baldoni is tasked as the director with going to break down what happened when he met with the intimacy coordinator so he could get her up to date on it all.
And spoiler alert, it's important because rather than assisting her, it provided Baldwin's squad the ideal opportunity to pursue the credibility of the entire campaign in the media. The attack by Fredman wasn't limited to Blake's. Asserts that he criticized the media's involvement in increasing them without the appropriate verification, now rather than on a high. On the occasions when Blake's team was endorsed, have to repel a whole new Yenti legal dispute regarding media ethics, reporting, and right when you expected it to. Couldn't get Brian to input any juicer. The attorney for Fredman, Justin Baldwin, who arrived with an extensive collection of legal munitions in the continuing conflict between Justin Baldoni, Blake Lively, and the Wayfair parties. The conflict jurisdiction is currently the main focus. Yes, you read correctly. Jurisdiction. The legal struggle is what might ascertain the course of the entire case. And spoiler alert, this is very important.
And they're arguing that California's tort claims, etc., damages in California are different because make their personal and professional homes, they may make claims in California.
This
is more than just the case's filing location. It concerns the location of reputations defended, and in cases of defamation, might strike Fredman's strategy the hardest. California, and he's making this very apparent. This case belongs in Hollywood, not New York.
But what Justin is saying is that California's substantive law should apply on this placing somebody in a false light.
The claim made by Fredman is basic California law provides much more defense in cases of slander, and that's precisely what he's pursuing. It is in California that Baldoni and the location of Wayfair parties is where their reputations are at the highest risk.
So California recognizes a claim for damages or for money for placing somebody in a false light. New York doesn't have that same law. What Justin, I think, is correctly saying is that, hey, I'm a California guy.
Let's be honest. The entertainment is in California, the playground of industry. Therefore, any harm to here, their image is more powerful than you would imagine that anything else would be. The initial indication of why California is the appropriate jurisdiction in this case. Instance.
All these other people in California, you, New York Times, based in New York, knew that publishing this story would impact me and others in California. So you reached out and touched us in California, so now California law applies.
The careers of the Wayfair party have taken a direct hit in Fredman, and California is not afraid to draw attention to It's possible that the New York Times sparked a media chaos, but the effects of the fallout were felt most sharply in the location where these men earn a living.
Yeah, I think it's extraordinarily difficult to sue a media outlet and be successful. Most of these are done just for press, like, oh, I'm suing the New York Times for all this money, and they end up getting, devastated. Here, I think he has a pathway.
Defamation laws in California are additionally more giving in terms of granting damages, and Fredman is aware of how to use leverage that he isn't. He's only trying to win. He wants to make a declaration, and where better than California will do it.
And even if it doesn't succeed, meaning he doesn't get to a jury, or a jury says, hey, I'm going to give you $1 or something like that, I like that he's exposing this because, we hope that journalists would actually investigate completely. We hope that journalists would give each side a fair chance rather than smearing and destroying one side.
Let's now discuss the actual. Here, Fredman isn't merely fighting. Additionally, where the case is filed, the New York Times is being criticized for ignoring the facts and acting rashly. See, when things were going well, posting this explosive during the Christmas season. Sitting there was article Fredman, wondering why they hurried it, leaving without providing the Wayfair parties an equal opportunity to reply.
The hypocrisy that Blake and the New York Times were doing the same exact thing, I mean, that's hard to ignore, no?
Fredman claims that they had a simple several hours to resist before the Times went ahead and published without hesitation. DRO the bomb with a great move, without considering the other viewpoint, to protect themselves, and naturally it's even worse. All of this occurred around Christmas is a really handy time of year. According to Fredman, this wasn't merely a case of subpar reporting, it was a intentional effort to spread the word, the door before thoroughly inspecting it, and that's blatantly dishonest
Reporting.
They showed that Blake is the one that colluded and conspired to get this movie and this IP out of his control so Blake could run the show. In that massive upload of documents, Blake leverages her friendship with Taylor Swift.
It doesn't end there. Fredman is prepared to call the times out for a much more serious real malice as demonstrated by U.S. defamation law. Real malice entails demonstrating that in this instance, the defendant is the New York Times was aware that the data was inaccurate or acted carelessly in disregard of whether it was accurate.
And are suffering in a public way. I think it's distressful, to say the least.
And Fredman has a strong argument here. He claimed that the era had all the internal records, communications, and proof they required to support Blake's assertions were dubious at best, yet rather than, the Times decided to run deeper with the story they wished to promote.
A lot of these people who turned their back on Justin Baldoni right off the bat, like he did a podcast called the Man Enough Podcast, and he did it with this woman, Liz Plank, is his partner in the podcast. Soon as this New York Times thing,
they didn't bother to check again. The information that they simply ignored. This is the part of the story where Fredman criticizes the Times for not just receiving the incorrect facts, but for misinterpreting them intentionally. This isn't only a mistake in exposing its malevolent intentions, and Fredman is not alone in this belief. The main focus of his legal challenge is holding the media behemoth responsible for his considers as careless and potentially dangerous reporting.
the dates are redacted, the names of the complainants are redacted, except for on one of them there's an M. And in Blake's original, when she went to Sony, and by the way, they're not to Wayfarer Studios, Justin's company, they're to Sony, the distributor.
Fredman doesn't avoid bringing up the fact that the Wayfarer was not even mentioned in the New York Times. Parties an equal opportunity to react to the grave charges. It wasn't just about hurrying up with the publication. Regarding the periods that are actively forming the storytelling without ever taking into account the complete image.
At least one of the other ones came around the same time. If it's May, unless it was March, but probably May, same time as Blake.
The Wayfarer parties were not allowed enough time to completely give their version of events prior to. The public and Fredmans were affected by the piece. The claim is that this was an obvious breach of journalistic impartiality. How Blake's claims were presented in the Times gave the impression that they had been confirmed facts, but in practice, they were only claims that the Times had neglected to confirm.
But I'm not really clear on why dates would be redacted. So it'll be interesting to see what the dates are. And as far as Sony is concerned, I believe there's a Variety article that I read that's published, that's out there, that says Sony received no complaints.
The primary issue with Fredman's challenges, the ethical dilemma facing journalists was, the New York Times is really curious about truth-telling, or was it more about promoting a story? In Fredman's opinion, the answer is clear. At times made the accusations seem as if they were unquestionable, utilizing their position to lend credibility to Blake's assertions by unquestionable reality, but they didn't care. Should devote enough time to a thorough investigation. Instead of verifying the facts, they simply followed the plot, and that Fredman arguments are where they went too far.
Is that they always say better to apologize and ask permission. Well, just not when you're defaming people. So here's what Lady C had to say.
Then naturally there's Lady C is a well-known person who isn't hesitant to express her opinions regarding how Lady C, celebrities control the media, has taken social media by storm, pointing out Blake Lively, as well as the New York Times, for her opinion that a meticulously planned public relations campaign created to ruin Baldwin's profession, and she's not. Lady C claims that she is holding back by confirming Blake's account of what happened. The New York Times unintentionally became a participate in this campaign of smears.
Here's what Lady C had to say as she sums it up. She's been following this. As someone who has had the last 5 decades of her life blighted by deliberate false reporting from newspapers.
The charge. Lady C is claiming that the era of discarding fundamental journalistic values and turning into another cog in the media machine of Blake, and if we're to be honest, her remarks are powerful, considering that she is not the only one bringing up these issues. The strength of the role of celebrities in influencing media narratives has never been clearer as it is now. Here,
I have every sympathy for Justin Baldoni and the Wayfair Studios victims of the smear campaign that the New York Times spearheaded on behalf of Blake Lively and Ryan Reynolds last December.
The obligation of the media to maintain objectivity and impartial is a fine balancing act, particularly when coping with A-list stars such as Ryan and Blake. However, this scenario has demonstrated how simple it is for Lively's balance to be tipped. Clearly, the PR team has worked out how to manipulate the media to their advantage, but Friedman of the New York Times claims simply followed it.
It is therefore gratifying to note that Brian Friedman, power attorney, has opposed the New York Times attempts to have itself struck out from the Wayfair lawsuit by simply making the point that that publication was not neutrally reporting on fact, but was actually propagandizing on behalf of the Reynolds.
They didn't pause to inquire, hey, are we obtaining both viewpoints instead? They were more inclined to use sensationalism, claiming that Blake's charges are true, which, as Friedman notes, led to significant harm to the Wayfair parties' reputations. The key query that still has to be answered is how much power ought the media to have in cases like this? Should they be the jury and judge, or should they simply remain together?
To the
facts, let's now discuss the courtroom drama, as that's where things truly get complicated. Will soon get delicious. Friedman has been insistent that this matter must be sent to trial. He also thinks that the media must answer for his actions, but he also desires a panel of peers to comment on the New York Times' status as careless in releasing its report. He says it's the responsibility of the court, not the press, will decide what's indeed the last thing anyone desires is the general population to determine this argument based just on headlines, and Friedman is promoting social media posts for a trial in which both parties may make their testimony before a jury, and let's confront it with all the complexities. And turns out that this is an argument for the
courtroom.
Some time ago, I pointed out that I had been told by an eminent Hollywood insider who deplores the way the Reynolds and their cohorts have been behaving, that the couple and the New York Times had been colluding with one another for months before publication.
Public opinion has a lot of power, particularly when celebrities are involved. This is precisely the reason Friedman is so insisting on a jury rather than the media should determine whether to hold a trial.
Permits the judicial system to adopt the
wheel and maintain the grounding of reality rather than allowing social media to. And the case is dominated by tabloids. Will be decided by the jury if it goes to trial. These reputations' fate is not a numerous, meticulously planned public relations initiatives or dramatic headlines, and let's be honest, Blake Lively's legal team is really located here. Under increased pressure each week, information is emerging that points to her. The 170-page lawsuit is on shaky ground. Document made public by Baldwin's group depicts the course of a campaign that, far more than only a court case, it's about preserving Lively's reputation. Earlier, attorney Merrill Conant bowed out, recognizing that there was no reliable foundation,
as well as laying out the unethical way in which the New York Times cravenly behaved. I can't see how Judge Lehman can possibly allow that publication to hide behind press freedom when it knowingly, unconscionably, and unethically allowed itself to be used as the disseminator of false information.
With additional details reveals how the general people views Blake's assertions are beginning to change. If Fredman wins the trial and gets his way, demonstrates that Blake's charges were constructed on sand. The once unquestionable reputation of Lively might fall apart more quickly than you might imagine. Media manipulation as the case progresses. Moving forward, it's evident that this is more than simply a court case. It's a clash of journalistic freedom, celebrity influence, and journalistic ethics. If Blake is able to preserve her image, or if the truth will eventually prevail. But one thing is for sure, certain that this case's repercussions will be perceived outside of Hollywood, and that's a wrap. Keep checking back for more surprises
and legal drama.